Welcome to JustWannaQuilt, a research podcast coming out of Tulane University Law School, where we explore all kinds of things, stories about quilting, tools, field trips, maybe some famous quilters stop by, and, of course, a little bit of copyright thrown in just for fun. This is Elizabeth Townsend Guard, your host, and I'm a law professor at Tulane University Law School and a faculty fellow at the A.B. Friedman School of Business at Tulane. And I just want to quilt. So today we talk to two people, Jessica Veeder of Jessica Quilter and Willa Olson. And this is a conversation about our new project, the Inventory Quilt Project, which I think is going to go on for a while, and we're going to explain it. It starts October 15th. We're getting ready for it, and we're announcing it on October 1st, 2019, the Inventory Project. Come join in. So today we have Professor Roberta Kwall. Bobbi Kwall joins us. She is the Raymond Nero Professor of Intellectual Property Law and the founding director for the Center for Intellectual Property Law and Information Technology at Depaul College of Law. She is also the leading expert on right of attribution, moral rights. So we're going to talk about what are moral rights. And finally, she is the author of the book called The Soul of Creativity, put out by Stanford University Press in 2010. And this book is great. If you like what she's...
My name is Roberta Rosenthal Kwall, and I'm calling from Chicago.
Awesome. And do you have any memory of someone sewing or quilting in your life? Like a first memory of something, of anyone sewing or quilting? Right.
All right. So here, deep, dark, dirty secret. So I actually, like most law professors, was a straight A student when I was a young girl, except for one class. The one class that I nearly failed, literally nearly failed, was home economics, which was a class that people took, back in that day. My mother, who is also not particularly gifted in the sewing department, had to actually sew the dress for me, and it got a C. But having said that, my grandpa, my mom's dad, was a fashion designer.
Really?
And but then he got sick and had to go into the dry cleaning business. So he really didn't he didn't ever make a living on that, but that was his plan. And his other daughter, my mom's sister, was actually very talented sewing wise. And actually in my office where I'm sitting right now, I have a painting. It's a needlepoint picture that my aunt did. It's not exactly nice. Quilting, but it's, in the
crafts.
same ring.
Right.
So I have sort of some talent in my greater family, but it's of absolutely no visibility in my line or my lineage. I have three daughters, as you know.
And your three kids don't sew or anything. That's
none of them do any of that. Right. Very so that's kind of where we are with that.
Awesome. Okay, so what I wanted to talk to you about. So tell me a little bit about what are moral rights? How do we understand what a moral right is? Because we hear this bandied about. But let's start from the beginning. And you are like the expert in the world on this stuff. So,
well, I don't know about that, but I've certainly done a lot of writing about moral rights.
Mm-hmm.
So that, that I guess that qualifies me as having some knowledge in that. So moral rights, which are protected by the vast majority of countries, including developing countries, except they are not well protected in the United States, and we can get into that. But moral rights are a segment of copyrights. They're usually protected as part of the copyright statutes in any given jurisdiction, in any given country. But instead of protecting the economic rights that copyright law protects, meaning the right to reproduce, the right to distribute, the right to display, the right to make a derivative work, etc., moral rights protect the personal interests of authors, especially the right to attribution,
right,
which can also include the right to be anonymous or to write under a pseudonym or create under a pseudonym, as well as the right to maintain what I call the message and meaning of one's work, which is known legally as the right of integrity.
Right.
So again, moral rights are the type. They are designed to protect the personal interests that creators have in their works, as opposed to the economic interests.
All right, so let's take one by one, and then let's figure out why you said not in the U.S. Because I think what's interesting is that I think these right of attribution is something that people care most about. Of anything that I keep seeing in this study is the right to be named and to be part of sort of, like, that's super important to people. So let's start with right of attribution. What is right of attribution?
Right. And, it is funny that you say that. When you say, Elizabeth, people care most about the right of attribution. I know you'll be able to relate to what I'm going to say in a moment. Right. So you and I both, work a lot with law professors and deal with law professors a lot. And as you know, in the legal academy, people are basically grouped along the lines of they're high protectionist, meaning they care a lot about maintaining high copyright protection. That's not most academics.
Right.
Most academics are low protectionists because they really are, very much moved by the ideas of, a more democratic discourse and freedom of expression. Not that I'm being critical at all of that, but when it comes to copyrights, that they do not like or favor or endorse strong copyright protection. When it comes to moral rights, they're kind of agnostic. Right. So they sort of, see the point of it, but they still question it, except when it comes to attribution for their work. Right.
That's right.
And then we get a totally different discussion going, right? So I agree with you. I think people do care a lot about that. And I think that attribution interests sort of are more acceptable, right? They're more politically correct, if you want to put it in those terms. I think integrity interests people have trouble with because they see it potentially damaging the freedom of expression. People should be able to use other people's works.
So give us an example. So right of attribution is the right to be named, or in some jurisdictions, the right not to be named, to stay anonymous.
Correct.
Correct. Right of integrity is a funny one. Tell us a little bit about what that means, right of integrity.
So the right of integrity means that, as I said before, I define it in terms of the right to have the meaning and the message of your work preserved. So what is the meaning of the work? I look at the meaning of the work, and perhaps your audience can relate to this, as what is the personal meaning that someone sees in the work, what the author personally sees as the personal expression and the meaning of that work.
Right.
I see the message as the message that the author wants to basically give to the world at large, more external. Okay. Yeah. But either way, the author has a right to have that preserved so that people don't modify the work without the author's permission. And if they do modify the work, it's very clear that this is a modification and that this wasn't the original work. Another issue that's very problematic, especially in the US, where what I'm about to discuss has no protection, even under the law that protects moral rights in a very skinny way, cabined way, is the right to not have your work presented in an objectionable context. So in other words, where your work is presented in a way that you would not have endorsed it. And so one of the best examples that I often talk about is the movie The Devil's Advocate. It goes back some years, but the problem in that movie surrounded the last scene where there was a sculpture that came alive, and the figures of the sculpture groped one another as Al Pacino, who was the star of the movie, the devil who came to Earth in the guise of a corporate lawyer, of course. And what he was doing in that scene was encouraging his two kids to engage in incest. Meanwhile, the backdrop was the sculpture where these figures came alive and they grope each other erotically. Well, that sculpture was a near exact reproduction of the sculpture Ex Nihilo, created by Frederick Hart. And so he was appalled that a work that he created for 13 years, during which time he converted to the Roman Catholic faith, actually was used as the backdrop for a scene in incest. Again, there have been many examples actually of this in litigation over the course of time. And to be honest with you, there's really no remedy. It's not protected by law here in the States, and there's nothing that you can do if somebody else owns the copyright to the work. So,
right. So, okay. So why doesn't the United States have these protections?
So I think it's largely political. For years, I would say early on, by early on, I mean, in the early 1900s, we are a capitalistic society. and we don't revere and value art in the way that some of our, particularly our civil law countries do. And so I think we don't have that history. The policies that have shaped the United States have been a much different type of policy discussion when it comes to copyright. And economics has really always been the preeminent right that has been protected in the US. When moral rights did come on the radar screen was a couple years after we joined the Berne Convention. We joined in '88, and the United States enacted the Visual Artists' Rights Act, which, as I mentioned, performs a very limited cabin type of moral rights protection for only visual artists and only certain types of visual artists.
Right. So take us through that. Let's why so limited? And sort of how do we, I'm going to try to get it up on my screen now.
Sure. Well, we can talk about why so. So VARA, the language of VARA provides protection only to paintings, drawings, prints, and sculptures. So in order to, and photographs, I will say as well, but only those taken for exhibition purposes only. And there's been litigation that if the photograph wasn't taken for an exhibition purpose, it doesn't get covered. So it's a very narrow framework.
And how do they define, do we know how they define painting? Is painting have to be with, like, paint?
Well, it also covers prints, but that would be a sort of a derivative, I would imagine.
Right.
So
which is a smaller definition, just so people recognize. So copyright protects pictorial, graphic, and visual arts, sculptural arts, right?
Yeah.
So it's broader than VARA. VARA is much more, right?
Well, copyright law protects any type of work of authors.
Right. But in that category, like, is the category of pictorial, graphic, and sculptural works larger under the general copyright law than it is under VARA? Or is it the same?
I would say pictorial, graphic, and sculptural works are probably subsumed under paintings, drawings, prints, and sculptures, right? So, okay. I mean, a graphic, could be, a print could be, it doesn't say what the print has to consist of, right? Nor what the painting has to consist of, right?
Got it. Okay.
So I think it's probably, probably one of the most on-point cases here is the case involving the landscape art.
Yeah.
This was in Chicago. Actually, it was a Seventh Circuit case, and it involved the landscaped art. It was the size of a football field, and the artist. And what happened was the city of Chicago kind of came along and chopped it in half, and changed it. And the artist Chapman Kelly was, really concerned and upset about what had happened.
Right.
So I remember actually sitting in my office one day, this was years ago, and one of our most prominent art lawyers here in the city, actually in the country, Scott Hodes, called me and he said, "What do you think? Do you think this football field of landscape art, would come under VARA?" And I actually said, no way, because VARA is very limited and it doesn't really qualify as a sculpture or a painting or a drawing. And so, but somebody took the case. I don't think it was Scott, but I don't think Scott took it, but somebody took the case and represented Chapman Kelly. And it had a very torturous history in both the district court and the Seventh Circuit. Bottom line was he didn't get relief. It was sort of the Seventh Circuit might have left open the possibility that VARA would cover it, but they rejected the claim, as I recall, because it wasn't totally human, because it's landscape art, and so the garden looks the way it does because of nature. And I don't think I would agree with that. I personally, I think if you're going to consider it landscape art, you're going to consider it under VARA.
And I think I remember that case because I remember teaching it. That they didn't even say it was copyrightable. I mean, they went so far as to not even give it copyright protection, much less VARA.
That was the lower,
right?
Yes,
that was the lower court, right?
Because they said it wasn't human, so it has to be human,
right?
Right. And I don't agree with that, because I think I've always my position is that the Chapman Kelly basically created the patterns, planted the seeds, and he mixed his work in, and just because it's sort of like copyright protects if you've got a painter, that quote in one of the famous older Supreme Court cases, if you've got the painter who there's a clap of thunder and the paintbrush moves and he has something that's not intended, it still can be considered, it can be embraced by the painter and considered her work.
Yeah.
I would say the same thing. If you've got nature and thunderstorms and whatever
it is, right?
Yeah. So
you're still the actor behind it and the author behind it. So therefore, okay. So visual art. So I've got up the definition, and it's interesting that the definition is a negative. So a work of visual art does not include any poster, map, globe, chart, technical drawing, diagram, model, applied art, motion picture or other audiovisual work, book, magazine, newspaper, periodical, database, electronic information service, electronic publication, or similar publication, or merchandising item or advertising, promotional, descriptive, covering, or packaging material or container. So I think that's super interesting. Oh, or any portion not subject to copyright protection under this title, which is the Chapman-Kelly one too, right?
Mm-hmm, exactly.
Okay. So getting back to crafts and art, we don't fit under any of those knots, right? We're not posters, we're not maps, we're not globes.
Right.
So does that mean that quilts could be covered by VARA as paintings?
I think you could. It's interesting because VARA also says what it does cover, right?
Yes,
There's a provision of VARA that actually talks about paintings, sculptures, photographs, but only for exhibition purposes only.
Right.
I don't know if you can pull that one up.
Yeah, I'm looking for this. Okay.
106, maybe.
When I have 106A up, let's see what writes. Let's see. Right, scope, and I'm looking.
Yeah, I'm looking as well.
I can see all the things it does. Duration, transfer, and waiver. I don't see the definitions. Are the definitions in 101? Or are they in 106A?
They could be in 101. I thought they might be in 101.
Okay, let me take a look. Oh, you think it's not under... Okay, hold on.
I'm looking as well.
I'm very exciting. No, I'm just kidding.
I
do this a lot. We do a lot of looking up because, that's just the world we live in. Okay.
Yes, exactly.
So for the people who are listening, we're at 17 USC, and 101 that's where the Copyright Act lives. 101 is the definitions, and 106A is where moral rights lives. So we're looking at what we're trying to do is see where quilts and crafts fit. I would say. Where is it? It's being elusive. It's the elusive definition.
It is.
Here it is. It's above it. So a work of visual art is a painting, drawing, print, or sculpture existing in a single copy, in a limited edition of 200 copies, or fewer that are signed and consecutively numbered by the author, or in the case of a sculpture, in multiple cast, carved, or fabricated sculptures of 200 or fewer that are consecutively numbered by the author and bear the signature or identifying mark of the author. That's the first one. Or, this is your second one, a still photographic image produced for an exhibition purposes only, meaning not for just clicking the kid, existing in a single copy that is signed by the author, or in a limited edition 200 copies or fewer that are signed and consecutively numbered by the author. Okay, so I think, what do you think? So here's what a quilt is. Let me tell you what the definition of a quilt is. A quilt is a unique object that is usually made, the kinds of quilts that are exhibited at quilt shows. They go for a lot of money. They usually have one copy, a single copy. I mean, there's patterns and other stuff, but the kind of ones that we're really interested in, they can come in any form. So it's a piece of fabric, something in the middle, batting usually, and then another piece of fabric. It can be a photograph. It can be whole cloth. It can be pieced. It can be appliqued. It is expression. It's artistic expression. There are protest quilts. There are all kinds of things that are, it is artistic in many ways. And they do get exhibited in museums. And they are a legitimate form of art at this point. Like they weren't before, a certain period of time, people saw them as bed coverings. I don't think that they can be useful articles, but I think it's aesthetically separable, the making it a blanket versus the art part. So that would be my definition of a quilt, is that it's the aesthetic elements of the quilt, not the comfort of the quilt, that we're looking at for VARA.
Correct. And I think that your definition, which comports with what I would have thought when I think of a quilt, being just a layperson in this regard, in the world of quilting, I think that would be that would sort of, I think, be a test case for Vera, in the way that the landscape art was a test case. Because I think it's very similar. It's not the same, obviously, but I think a lot of the elements that make landscape art somewhat questionable. I mean, I guess landscape art is probably more closer to a sculpture. Quilting, I'd say it's in between maybe a painting and a sculpture. I don't know.
Maybe drawing. It just depends. I mean, the top part is definitely drawing. You're just using you're using thread to draw, and then and the painting is, you're putting layers of different fabric together. It could be a sculpture. I don't know. I think it depends on what the quilt is. I mean, these quilts can get really amazing and varied in many ways. So I mean, I think you're right. I don't think it's like, I think you have to sort of figure out how would the court define a quilt, and then if they defined it under painting, drawing, print, or sculpture, it would qualify.
Exactly. And one of the problems is that Vera has had a tendency. You asked why it was so narrow, and we never really talked about that in terms of what happened with the statute. And the statute was basically, when it was enacted, this is 1990, it was sort of appended to a bill called the Federal Judgeships Bill. And there were and Vera had been blocked in the Senate by certain Republican senators. So when it got appended to the Federal Judgeships Bill, which the Republican senators wanted, that it got passed. So it was one of these sort of add-ons to another bill that was really wanted by the senators that had been blocking Vera, so that was political. But as a result, there was very little, very, very little well thought out discussion. I remember being asked to give some written testimony, and I did. My testimony was about the takings issue, the retroactive application of it. But there was very little well thought out discussion. And if you look at other parts of Vera, it's a very problematic statute. Elizabeth, the duration is problematic. The subject matter is problematic. The waiver provision from one joint author to another is, one joint author can waive the Vera rights of another joint author. It's all problematic. So I don't know, you may know this, I'm sure you do, but last year, the Copyright Office did a study of Vera, and I remember seeing the comments like, "Oh, they're finally going to look at Vera. It's been 10 years since I sold the creativity. They're finally looking at it." Right. So I submitted a lot of commentary on it, and when all was said and done, they made minor recommendations, like, okay, yes, we should make the duration provision not bifurcated but consistent, not dependent on when the work was created, and the waiver provision for joint authors. They're
terrible. Just cleaning it up. They were just doing little cleaning
very
up.
light, dusting, very light dusting with a feather duster. That's a good, but really nothing serious. And so that was, to me, disappointing. And the reason they didn't do anything more was this, notion that our patchwork protections work well. I would beg to differ on that. And I think quilting represents, again, I'm not aware of a case on quilting under Vera.
I haven't seen it either.
Yeah, and you would certainly be on top of that with the podcast. But it does seem to me that when you have the right set of circumstances, when you have somebody who gives the quilt to someone, let's say, a quilt with a very special meaning and message, and they give the quilt to someone, as you know, the quilter still has the copyright. Right. They don't assign the copyright when they give the quilt itself away. And if that quilt were displayed, let's say, in a context that the original creator didn't approve of, or if it was modified in some way and still attributed to the original, that would be your test case.
Yes.
I personally think quilting should be covered. I personally think Vera should cover a lot of things that it doesn't cover, like literature, like writing, like music. None of that's covered.
None of it's covered, just artwork.
But the problem is that the courts know that Vera was narrowly drafted. And they also know, and this has been in some of the moral rights cases, like what Congress wants to draft more broadly, they know how to do it. Right. They drafted very narrowly.
All right. So let's just pretend that quilts are covered. Let's get past that.
The big pretend, but yes.
Okay, we can totally pretend. I believe they are covered because I think they are artwork, and I think they are just another form of painting, drawing, or sculpture, depending on the type of quilt. Not all quilts would cover, there's commercial quilts and there's, I don't know. We're not going to worry about that. We're talking about art quilts that are being exhibited in shows and museums and galleries. Okay. So what do you get? So, okay, we qualify. What happened? Like, what do we get if we qualify for VARA?
Well, you get, for example, if your quilt is considered of recognized stature. And by the way, that report I was just talking about, one of the things that they did suggest is that the definition of recognized stature, which has always been very heavily dependent on academic input and what the experts think, should now be a little bit more broad, community.
Okay, so let's pause there. So VARA only covers things of recognized stature?
For destruction. That's what I was about to say. Right. The destruction.
Those are the street art cases, right? That's pushed it in really lovely
So you would get
ways.
the right to prevent destruction if your work is, or damages if it was distressed, if your work is of recognized stature. You get the right of positive attribution. All right. So, and if somebody else's name is put on your quilt, you get the right to, of course, object to that. So you have attribution rights. You have integrity rights when the modification is intentional.
Yeah.
Right. And prejudicial to the creator's honor or reputation. It's got to be prejudicial. So again, the standard should be, what does this do? What does it do to the personal interest?
So we saw this great in Atlanta, this great exhibit where someone had taken an old quilt, not probably under VARA, and had dyed it black. And it was so shocking but you could take somebody whose work is like really well known, buy it, and then dye it black and hang it. That would be, not only you've kind of created derivative work, but you've also, VARA would sort of kick in and
VARA
say,
would, if quilts were covered, VARA would cover that, yes. Right. Because you're doing an intentional modification.
That's right. And it may horrify the owner. Right.
Yes.
The author.
Yes.
Okay.
Yes, exactly.
Okay, so you get right of attribution, and you prevent your name from stuff you did not create. So that's interesting, right? To prevent the use of his or her name of which you do not create. So you can't.
Well, that covers non-authors, actually. That right covers people who aren't even authors, right?
Yeah.
Like if somebody uses your name, let's say Elizabeth, on something that you never created, right?
Yeah.
You would have that right. I mean, that's actually one right of VARA that goes to people other than
people. Got it.
Right. Exactly.
And then the right to use distortion, mutilation. So that's the right of integrity. And then the sort of destruction, as long as you have a national, what kind of a substantial?
Work of recognized stature.
Work of recognized stature, which is so interesting.
And there's been a recent case that has adopted a more flexible definition of recognized stature.
Interesting.
And then, and the last right is sort of a combined attribution, like when there's an integrity violation with attribution, you get, together, you get the right to
both.
That.
Right. Yeah. Okay. All right. So then there's a whole bunch of exceptions. Like it can't be a work for hire. What else can it
subject
result
to fair
of passage of time. So if it fades, that's not a violation of.
That's not an intentional right.
Right.
Yeah.
So you've got a bunch of limitations, and then tell me a little bit about the duration part of it.
So the duration is problematic. So the duration basically currently, the current duration under VARA is that if the work is created after the enactment of the Visual Artists' Rights Act, after 1990, copyright law lasts for the life of the author. Right? But if it was created before VARA and the work has not been transferred, okay, in other words, if the title has never been transferred to anyone else.
The copyright title. The object itself couldn't be transferred, but the copyright still is with the author.
Right. Then you get copyright protection for which is life plus 70. So that's crazy.
So why did they so for those listening, currently copyright law is life of the author plus 70 years. And so for new things, 1990 and later, it's only for the life of the author. But for old things, it's life plus 70?
Correct. And nobody has any again, that was one of the things that I talked about, years ago
really
as being ridiculous. And nobody has any nobody has any explanation for that. Like why, nobody knows why it did that. Remember I told you the history of the statute was very frenetic.
Right.
Right.
Yeah.
And not considered and not well thought out.
All right. So interesting. So let's say, so let's take a scenario. So I am a super famous quilter. Let's pretend. Okay. And I exhibit my work. Oh, there's been these, and then somebody does post online or claims it as their own or leaves my name off. Okay. How does Vera help in any of these situations in terms of, like, you have to actually go to court? Like, this is a lot. I mean, how effective is Vera in protecting artists from these two issues of right of attribution and integrity?
Well, like anything else, I mean, in order to enforce your rights, you have to go to court, right? Yeah. So, I mean, a lot of artists don't know about Vera. I mean, that's why this is a good, podcast to do, because a lot of, and there's been surveys of that establish that many artists are completely ignorant about Vera, and the fact that also, Vera, they just don't know. So, I mean, you'd have to go to court. You'd have to protect it.
Do you have to have your work registered to have Vera? Like, for copyright infringement and going to court, you have to have your work registered with the Copyright Office. Does Vera require registration as well?
I don't know that you actually have to.
It comes under the copyright
I think you have
law,
copyright
right?
protection automatically. So I think if you want to file a lawsuit, you need to register. But you have the protection.
Right, but to enforce it, you have to have had now with Fourth Estate, you have to have a registered work. I mean, you have to have a registration certificate. Right. I would imagine that that's true with Vera, because I don't see any kind of exemption for it.
No, I think that's absolutely correct.
Interesting.
Absolutely.
Do you think that if the small claims court goes through ever, which people say it's not, but it's up again, like we keep seeing the revive. Pre-72 sound recordings went through finally, so I'm like more like, are they going to slip in small claims when people aren't looking, the way they did with pre-72 sound recording protection? Do you think if there is a small claims court that Vera will become more robust? If
maybe, more access, greater access, right? Possibly.
Right. Cheaper.
But again, they have to know, though. They have to know. They have to know that they have these rights.
So how successful do you think Vera has been? Like, as artists, like, if you're like, most of them don't know, you have to register your work, you have to sue. It has to be a big thing happening. Like, you put your images on. I mean, your work is on a building that's going to be torn down. I mean, it has to be something huge for it really to trigger. Is that right?
I think that's right. I mean, I think as a practical matter, most artists don't even know about Vera. I meet artists all the time. Like, just perfect example, Elizabeth. And again, this isn't quilting, but just the other day, I had a meeting with a painter because my new book and her recent showing sort of have a similar theme. So I went to her home, which is very close by to my home. And she said to me something like, "Oh, I tried reading my last book, The Myth of the Cultural Jew." She said, "I tried reading that book." She said, "It was very academic. I couldn't get through it." I said, "The book you really need to read is The Soul of Creativity." And I said to her, "Do you know about moral rights?" No clue. She's been training for 30 years. She had no clue what moral rights were.
So why did you call your book The Soul of Creativity? I've always wanted to ask you, like I love that title. Tell us, and that's the book. So if you want to learn more, so those listening, if you want to learn more about moral rights, this is the book to read. We'll put a link up so that you can get to it on Amazon. But tell me more about why and what drew you to this subject, because you spent a lot of your time looking at moral rights. I'm curious how that happened.
Right. Well, how did I? My very first published article as an academic was on moral rights. This was back in Vanderbilt, where I talked about copyright and moral rights as being cousins, I believe. Yeah. And I don't know. It's interesting because I'm not an artistic person visually. I mean, I don't do art. I write, as you know, but I don't do art.
Right.
But I've always been very drawn to the law. And I think it's because, having had a long time to really contemplate my attraction to this area, I think it does relate to the spiritual sense of creativity, because I'm a very spiritual person, as you know. Yeah. And I think that's the piece of it that always has fascinated me, that what moves an artist to create. Yeah. So the book, The Soul of Creativity, it was, in some ways it was, by the time this book was, I started teaching in 1983. I wrote about moral rights. The Vanderbilt piece was 1985. So Soul of Creativity is published 2010. So I've been writing for a long time about it. But what the Soul of Creativity really tries to do that's different is look to the motivations for human creativity. And that got me back to creativity theory as the artists are describing it and the philosophers, as well as the different religions. So I looked at Judaism and Christianity and what it had to say about what motivates human creativity. And so the title, The Soul of Creativity, I think really drew from my work of looking at the different religious traditions and what motivates human creativity, going back to the creation narratives in Genesis, the first book of the Old Testament. And if you look at that, you can see a very clear path for human creativity, and there's a lot of interpretive context of that. It certainly in the Jewish tradition, and Christianity is very similar to Judaism in terms of how it looks at this. So that's how the title, I think, it was tapping into this.
Why do we create? What is it about us as humans that we do quilt or paint or write music?
Sure. I think that is one of the mysteries of God's creation, in my view. I think why people create is one of those mysteries. Some people would say, those who are, more religiously as opposed to spiritually oriented, some people would say, we create to be partners with God in the creation. That's the classic Jewish, one of the classic Jewish theories about creativity. We're commanded to be partners with God in creation, and how we do it as our human creation. I think other people who have a more spiritual sense, but maybe not as directed toward a particular religious tradition, might say, well, we create because that's how we express the hope and darkness in an external, form. I mean, if you think about it, if you think about the Holocaust, and I know that you know a lot about that topic, I know that was one of your areas of expertise, but you think about all the artwork, not just the visual art, Elizabeth, but the music, all of it, and the literature that came out of the Holocaust. I mean, and people knew that they weren't getting money for this. They didn't create to get money. That's always been my problem with the United States, because the notion for why people create is so much more spiritually focused than money.
I totally agree. It's interesting because, we get this dual tradition of like copyright coming out of England versus copyright coming out of France, and sort of the importance of the artist coming out of France, which you know much better than I do. But as I think about, this project's been 2 years of me quilting every night. And as I quilt, sort of thinking about copyright and thinking about why we create and thinking about all these things. And I just think that even the people who are, they're making their living from it. I don't think the space that they're in, I'm just really curious about, like, as you're creating, like, is it always about, that's one of the things we're trying to get to, is this notion of, are you putting like, I'm making this frog because it's going to make a lot of money, or you are in a sort of more spiritual or artistic space of like, I'm making this frog. I know people like my things. I think this may make money, but that it is, I think most of the time what you're saying is that we're creating because we want to create. Yes. That it is a separate thing, which is ironic that 106A is like this evil stepchild or the stepchild or the neglected child of copyright, when it's the essence of copyright, which is so interesting to me. This sort of, I've created it, this is mine, right of integrity, right of, I care what happens to it. I care that my name is on it, and then it's only a small subset of artistic works where copyright protects everything. It's so interesting and weird.
Yes, I couldn't agree more. And I think the stepchild analogy is a good one. It's very creative, Elizabeth. I like that. And I think that's true. I mean, it's always sort of been about money. And I'm not saying that there aren't artists for whom money is paramount. It's not a black or white situation. But by not recognizing a more substantial level of moral rights in the United States, what we really do is completely despiritualize the creative process. Well, and that's a problem.
Yeah, I think what's interesting about it is it really does tell you that copyright's an economic system. It's always been an economic system in the U.S. It's not about, and that it really did only protect things that were being mass reproduced, books, other things. As new technology came into play, we had to sort of identify it. But it wasn't really meant for the artist. It was meant for the producer of the materials. And that becomes really clear when you think about, like, well, what about, what about my art that I care about so much, right?
Right.
It's not about that. It's about, and so one more part to the story I'm really curious about, because we've been talking to people in different contexts. How does user-generated content, the ability of all of us to make things, alter this? How does it shift it, and does it put pressure on VARA or other parts of the Copyright Act?
So, that's a great question. And I deal with that in the Soul of Creativity. I talk about that. And I talk about the fact that it's it's a problem because it's so much easier in the digital age to manipulate content for better or worse. And so the joint authorship component, becomes problematic. The integrity component becomes problematic. And I think it's just one of those areas that the law just has to sort of work its way out. As of right now, again, it's limited because VARA doesn't really cover user-generated content.
No.
It covers
artwork, right? And it's all about the single. It's very traditional. It's high fine art is really what it's sort of focused on, not posting something on the internet.
Exactly.
Unless it's an infringement. Unless you're if you make some artwork and then it gets on the internet and there's some issues and blah blah blah. So I think that's super interesting. Okay, one more, and then the last piece of this is fan fiction and fan art. So when I dress up as something, there's a sense of that soul of creativity thing happening again. Like, the reason I want to be that character is because I love it and I feel connected to it, and I make my own costume, and it's got all that stuff, but not protected at all by copyright or even VARA, and you're using somebody else's material, right? Some other character that's protected by copyright, although we have spaces for this. So I think that's fairly interesting too, this kind of personhood theory, or it matters to me so much that I make it. How does that fit into this conversation?
So moral rights are very steeped in personhood. That's really, the one of the philosophical foundations for moral rights is a recognition of human dignity. It's really about human dignity, which is personhood.
Right.
And so you really can't. The reason we protect moral rights, and the reason we should protect moral rights, is to recognize the human dignity of individuals. Yeah. And so what you're talking about, that choice to participate in the fan fiction, is really about protecting, human dignity. Now, the question is, your choices are protected. The question is, whether the actual result is protected, and if so, through what mechanism. That gets a little bit more difficult, right?
Yeah, it gets very complicated, right?
Yeah,
so
exactly.
Interesting. Well, I think this is really awesome. I'm so excited that you came on and that you made some time for us, because I know you're super busy. And I think this is a super important conversation to start having, is sort of where VARA fits with, because I think if quilting doesn't count under VARA, that's saying something about the status of quilting in the art world. And so I think it's an important conversation to be having, because I think it's not useful articles, it is art. And I think we're finally, at a point where it's enough of that, enough wondering whether quilting is art. And it is. So
it is, absolutely.
And
absolutely.
I guess my question is, other forms of art may not be, if other forms of art are not protected under VARA, that's okay. But, if it's sort of I imagine performance art isn't protected, or some sort of weird...
it's not fixed, so it doesn't have copyright protection.
Right. So, I guess that would be the question. But we don't have a fixation problem, definitely, because that's all we're doing is fixing pieces of fabric very aggressively to other pieces of fabric.
And I don't think you have the originality problem in most instances. So that was the problem with the landscape art case. It was lacking originality because of the lack of human authorship. And you certainly don't have those problems.
No, and we don't
I think a very strong case can be made.
Yeah, I think so too. Awesome. Well, I adore you. Thank you so much. Do you need to review this before we post it? Or are you good?
No, I think I'm good. I'm good. Cool. I trust you.
Awesome. Okay, well, thank you again. You are so my very favorite forever and ever and ever. So I'm so psyched to chat with you. I'm going to turn off the recording, but don't hang up.
No.
Okay, cool.
The recording has stopped.
So you've been listening to Just Wanna Quilt, a research podcast coming out of Tulane University Law School. And I'm Elizabeth Townsend Gard. If you like this podcast, keep listening. Also, we have a Facebook group. Come join us. We talk about a lot of things. We also have an Instagram account. And of course, most importantly, I really hope you get a chance to quilt today.